We will call the Physician Assistant Board to order. Today is July 11th, 2016, and we are meeting in Sacramento, California. First item on the agenda is to swear in a new member. Governor Brown appointed Jennifer Carlquist to the board. Jennifer has been an emergency room physician assistant at Community Hospital of Monterey Peninsula since 2013. Also a physician assistant at Central Coast College Cardiology since 2012, and an emergency room physician assistant at Salinas Valley Memorial Hospital 2009-2015. So welcome, Jennifer, and we'll step up to the front and give you the oath. Raise your right hand, look at the camera. I, Jennifer Lee Carlquist,
I, Jennifer Lee Carlquist,
do solemnly swear or affirm
do solemnly swear or affirm
that I will support and defend
that I will support and defend
the Constitution of the United States
the Constitution of the United States
and the Constitution of the State of California
and the Constitution of the State of California
against all enemies, foreign and domestic,
against all enemies, foreign and domestic,
that I will bear true faith and allegiance
that I will bear true faith and allegiance
to the Constitution of the United States
to the Constitution of the United States
and the Constitution of the State of California,
and to the Constitution of the State of California,
that I take this obligation freely
that I take this obligation freely
without any mental reservation
without any mental reservation
or purpose of evasion,
or purpose of evasion,
and that I will well
and that I will well
and faithfully discharge
and faithfully discharge
the duties which I am about to enter.
the duties of which I am about to enter.
Congratulations. Welcome
Thank
to
you
the board.
very much.
Okay, next item, we are losing our attorney, Christy Schley, and we have a new attorney taking her spot. Her name is Ileana Buto. Ileana has been an attorney with the Department of Consumer Affairs since May of 2014. She has provided legal assistance to various boards and bureaus such as Osteopathic Medical Board, Neuropathic Medicine Committee, Board of Occupational Therapy, Board of Registered Nursing, Bureau of Real Estate, Bureau of Real Estate Appraisers, Bureau of Private Post-Secondary Education. Prior to joining the department, Ms. Buto worked in the private sector representing public school districts and county offices of education, specializing in special education issues and litigation. She advised clients on compliance with applicable law, negotiated agreements, and did presentations for clients and professional organizations, such as the Association of California School Administrators and California Association of School Psychologists. She also handled cases before the California Office of Administrative Hearings, Special Education Division, the United States District Court of Eastern District of California, and managed complaints and investigations before the California Department of Education and the United States Department of Education Office of Civil Rights. What do you do in your free time? So, Ileana, welcome.
Thank you.
We appreciate you for
Nice to
being with us, and we will miss Christy.
And to see you.
You may.
Okay. I've really enjoyed working with all of you for the past 3 years. I'm sad to go, but I'm leaving you in good hands. She's not only intelligent, she's great to work with, has great disposition. So I think you will be very pleased with her representation. I have a lot on my plate right now, personally as well as professionally, so unfortunately, the office made a decision, not me. I didn't request it. Just want to make that clear. But in any event, I will miss all of you, but I will potentially be covering the October board meeting. It's not clear right now. Ms. Butu has some plans, unfortunately, that conflict with your October meeting date, unless the meeting date changes. And so she won't be able to attend the next board meeting. So it'll either be me or one of your prior physician assistant board councils.
Okay, thank you. We'll miss you. All right, Anita, can we call the roll, please?
Charles Alexander,
Present.
Michael Bishop. Here. Jennifer Carlquist,
Present.
Sonia Early,
Here.
Javier Escoval Acosta.
Here.
Jed Grant,
Here.
Catherine Hazelton,
Here.
Xavier Martinez. Robert Sachs.
Here.
Mary Valencia.
Present.
Okay, we have a quorum present. I would just like to take a moment. This is the first time in the history of the Physician Assistant Board that we have ever had 10 members, 5 PAs, 4 public, and 1 from the Medical Board of California. So this is a rather historic day, for whatever it's worth. But I will also state, just to make it clear, that because we have 5 voting PAs and 4 voting public members, Dr. Bishop, who represents the medical board, is not allowed to vote. So as a result, during closed sessions, he will be excused from the room. And we're sorry for that, but that's the way the legislature decided it was going to be conducted at our 2012 sunset review. So without further ado, the next item on the agenda is approval of, unfortunately, it was listed as the January 11th minutes. It should have been the May minutes. So we will not be able to approve those minutes today. That will have to be moved to the next meeting. So item number 4 on the agenda is approval of the minutes from the May 16th Specialty Training Program Review Committee meeting.
I would just request that it be acceptance of the minutes because it's a committee that not all the board members were on. So they might want to suggest, if you agree with what's written here, to accept.
Okay,
I'll make a motion to accept.
I'll second that motion.
okay, so does everybody vote or? Okay, so further discussion? Okay, I will call the roll for the vote. Public comment? Seeing none, we will call the roll. Dr. Alexander?
Aye.
Jennifer Carlquist?
Aye.
Sonia Early?
Aye.
Javier Escoval Acosta?
Aye.
Jed Grant?
Aye.
Catherine Hazelton? Xavier Martinez?
Aye.
Robert Sachs? Aye. Mary Valencia?
Aye.
Okay. Next item is number 5. Public comments on items not on the agenda. The board may not discuss or take action on any matter raised during the public comment section that is not included on this agenda, except to decide whether to place the matter on the agenda for a future meeting. That's California Government Code, Sections 11125 and 11125.7A. Next report is the President's report. First item is the California Academy of Physician Assistants. We will be having their annual conference in Palm Springs in October of this year. They have provided the PA board with a booth. Any of the members are welcome to come and man that booth. There will be no reimbursement for travel or hotel though, so it's on your own dime. It's a wonderful opportunity to meet the licensees. They have between 700 and 800 PAs that attend. some of the members of this board will be lecturing at that. So, any public comment on that? Okay. Next item, in your packet, you have some documents from the American Academy of Physician Assistants, their attorney. There seems to be an issue of the American Academy of Physician Assistants and the National Commission on Certification of Physician Assistants, which provides our licensing exam and also our recertification exam. They have come out with a new method of recertification, which turns it into a 10-year instead of a 6-year process. And there is considerable expense involved in this new way of doing the recertification. At the national meeting of the AAPA, they took a position in their House of Delegates that they did not see that this was an appropriate way of recertifying PAs. So this is more informational than anything else. The letter is from a law firm that the American Academy of Physician Assistants has retained. And I know, Jed, you may have something more to throw in since you're in a program.
I think in terms of, maybe not so much of an issue for California because we don't require NCCPA certification to maintain licensure. This is, I think, a much bigger issue for those states where they have to maintain their certification to maintain licensure. But it is a big issue in the PA world right now because it's high-stakes recertification, so I think it's a good thing for us to watch. That's all I would add.
Okay, any other comment, Christy?
Yeah, the only possible nexus is that under current regulation, people who maintain their national certification are exempt from certain continuing education requirements. So there is somewhat of an advantage if you have your national certification, you get exempted from the CE, and you just need to maintain your national certification as evidence that, and so that's the only California intersect that I see. If this was an initial licensure issue, we might have an issue that we need to talk about with respect to the antitrust issue. But as Mr. Grant correctly pointed out, since California doesn't require it to be maintained for renewal or maintaining the licensure, then this particular issue doesn't appear to have any impact on California licensure.
I might just add that the CME requirements from NCCPA are more rigorous than the state requirements to maintain continuing.
So that
medical
makes
education.
sense why you would have that exemption in regulatory law, so.
Okay. Is there here? Okay. All right. Next item on the agenda is a difficult one. Michael Scarano, who was the CAPA attorney for more than 25 years, passed away about 6 to 7 weeks ago. Michael was a partner in the law firm of Foley and Landers, which was a large national firm. He changed the PA profession. His footprints are all over PA laws and regulations. Any PA that writes a written drug order should think of Michael because he's the one that made that possible. In 1989, he worked with CAPA and the Physician Assistant Committee at that time on our regulations. It took 3 years to get those regulations passed through the process. But as a result of that, PA practice changed significantly. Mike was a family man. He had 2 daughters, a son. One of his daughters, Amy, just graduated from Western PA program, and Michael was able to attend that graduation. Michael was a gentle man. He was also a sportsman. He loved fishing, and he loved tennis. To me, he was a very good friend. We had the opportunity to give lectures together at the CAPA conference, and it was always a pleasure to work with him on one of those. He wrote a book on PA laws and regulations, and as a result, has published 4 editions now. At one point, the executive officer of the medical board purchased copies of that book for every member of the medical board because it was so concise and informative about the PA profession. Last year, he was awarded CAPA's highest award, the Pride of the Profession Award. We have lost a giant too soon. He was only 58, and we were all touched by him. Future PAs will also feel his touch. CAPA produced a special video, which can be found on their website, which was produced for the award. It was played during his memorial service that I attended, and there was not a dry eye in the place. Michael was one of the good guys, and he will be missed. Thank you. With that, that concludes my president's report. We will go to executive officer report, or do you want to do budget?
Let's do budget.
Okay, we'll go out of line, and we will do the budget next. You don't have your armor vest on, Bill Wilbur.
It should be fine. Good morning, everyone. We're here to do a quick budget update regarding 2015-16. And if you guys go ahead and look at your packets, I'll go over your expenditure projections for this year, or technically last year. So we're in the middle of wrapping things up for the last fiscal year. So if you look at your expenditure projections, it's changed a little bit. There's a couple items I'm going to talk to you guys about. And if you have any questions, just go ahead and chime in and let me know. First thing I'm going to talk about is there was, based on budget bill language, there was an AG augmentation that you guys got. If you look at your AG light item, you guys received a $180,000 AG augmentation. Because I guess due to the complexity of your cases this year, there's a couple of items that I guess pushed you over your allotted amount for this current fiscal year. The second item I'd like to talk about is the CMP Services external line item. I have you guys expended for $114,000. I know this is going to look a little off, but my projection shows that it's only $40,000. The reason there's such a big difference on that line item is due to the fact that the current year expenditures include the year-to-date expenditures plus encumbrances, but based on the information that I've been working on with Glenn and Lynn, it looks like the actual expenditures for mainly the Maximus contract, you guys didn't expend that much, so it's going to be significantly less than what it shows in the expenditures. So to date, again, your budget is close every year. So as you can tell, the reversion that I have you guys projected for is roughly $36,000 at this time. And I've been working with Glenn and Lynn for the past couple weeks to ensure that you guys don't fall into the red for this fiscal year. And it looks like that's going to happen. So, yes.
So we have a retirement coming up, and in the past, that has sort of sent us off the cliff into the red. Have you prepared for that?
There's a couple of things. I have. It's a new fiscal year, so it's something that we can account for as long as it falls into this fiscal year.
I think it will.
Yeah.
Okay.
Should we put in for another augmentation early in this new fiscal year, since we know we're going to need it before the end of the next fiscal year?
It's okay. So it's time for budget change proposals. So at this time, we are working on submitting something, but until it's finalized, we won't, we're working towards that, but until everything is finalized, we can't really speak about it.
Is that you're referring to 17-18 for next year?
Yes.
17-18. Yeah, you would do that through the BCP process.
Okay.
But there's also, the reason we're able to do it this year is, and I believe it's,
Budget bill language.
yeah, budget, that's right, budget bill language that allows boards, when you overexpend your AG budget amount, that in the current year you can request an augmentation. So even if you didn't go forth with the BCP and in 17-18 you go over your AG budget, you can still get an augmentation within that same current year to make sure you have enough expenditure authority. So you don't have to necessarily go through the BCP process because of that budget bill language that allows you to get an augmentation in the current year.
Okay. And one other question that I have, are we really going to get the 1.5 million from the governor this next fiscal year?
Yeah, the governor said he wants to pay all loans back at this time. So at this time, you guys are scheduled to get the 1.5 million back in 16-17 this fiscal year.
Okay, that's probably a good thing, because I think if I look at the numbers, that would probably put us over 24 months and potentially
It's close.
we'd
Yeah.
have to start reverting money back to.
Yeah, and if you look at the expended or the fund condition, there's a caveat on there that says with current year expenditures and revenues. So at the time when governor's budget was built, you guys were, for the revenues, you guys were estimated to collect $1,660,000 at this time currently projected based on what you've currently brought in up to fiscal month 11, which is May. The board will collect $1,688,000, so roughly $28,000 more than what was projected.
Okay. Other members have questions? Our accountant doesn't have any questions? Any other? Public comment? All right, thank you very much.
And I forgot to, didn't get to introduce myself before, because I might be seeing you guys at the next meeting. I'm Maureen O'Connor. I'm a new budget manager, and Cynthia Dines is retiring, or has retired as of June 30th, so I'm replacing her. So thank you, and look forward to working with you
Okay,
guys.
well, welcome. Thank you. All right, so we will go back to the agenda item, Executive Officers Report. Glenn Mitchell.
Thank you. A couple things to talk about today. I'd like to update you on the Breeze implementation. Our new online PA application became live on June the 17th. And with this application, now individuals can submit the application online, and the only thing they're required to submit in writing to us is an attestation page, which is their signature as well as a photograph. So far we've been getting applications this way. We think it'll save a lot of staff time, and it'll be very convenient for licensees or applicants to apply online versus having to go through the paper routine. We still have the option of the paper application as well. Another feature we're adding, this will probably be sometime in late summer, early fall, the ability for licensees to update their addresses online. Currently, the only way to do this is either to submit something in writing, either through a letter or fax, or we have an email system where we actually then have to take the address and then actually change it. So this new feature will allow individuals to go in there and update their records without us having to get involved in that process. And there again, that will save a lot of time, and it will be efficient for licensees as well. The final thing with Breeze, the Breeze team, in addition to the boards, is working on a new email feature that, for example, with app licensees getting ready to renew, they'll receive a email when the renewal is first available. Then they'll get another email 30 days prior to the expiration, and then they'll get an email when they renew. They also will get an email if they're delinquent. So they're working on that feature. I don't have a time of when that will be rolled out. The other feature with the email system will be applicants, once they're licensed, can receive an email stating that their license has been issued. So it's important that licensees and applicants provide us their email address, and then they can take advantage of that system as well. We're still working on reports. There are still some errors, but our staff is working with the Breeze team in addition to other boards to try to make the reports more usable than they are. And again, I'd like to thank the Breeze people as well as the medical board for helping us. Any questions on Breeze?
I do. I just want to make sure we're still at a 24-hour turnaround once the payment feature has taken place.
The what fee?
I think once the payment goes in, it's a
It's
24-hour.
instantaneous.
Okay.
In other words, when you renew, it will immediately, once you pay it, it is updated.
Okay, great.
So that feature will be working.
Perfect.
Okay.
Thank you.
Okay. The next thing I'd like to talk about is the Cures update. All California licensed healthcare practitioners authorized to prescribe Schedule 2 through 4 controlled substances were required to register with Cures by July the 1st. We put on our website a Cures countdown calendar, as well as we sent a blast out to individuals on that list notifying of the change. I've included a Cures activity report, kind of to give you an idea of the activity on Cures since I think that the report is as of June. Any questions on Cures?
It looks to me like there's about 6,500 PAs that haven't signed up. Am I reading that correctly?
Mhm.
Do you have any idea?
That could mean they don't need to, or they're not transmitting scheduled drugs. That could be a possibility. Some PAs have had that authority revoked, either through discipline, and perhaps there's individuals that just haven't gotten around to doing it. But there are PAs that are not prescribing or transmitting scheduled drugs, so there would be no need for them to sign up.
Okay. And it looks like of the PAs that are signed up, they're pretty heavy utilizers. So,
It appears so.
good and bad. Thank you.
The final thing I'd like to talk about today is the End of Life Option Act, and that was Assembly Bill AB 15, and it established the California End of Life Option Act, and it commenced with Health and Safety Code Section 443. The act gives a mentally competent adult California resident who has been diagnosed with a terminal disease the legal right to ask for and receive a prescription from his or her physician to hasten death as long as specific criteria is met. We have developed an information bulletin for physician assistants regarding the act, and basically our bulletin states that the criteria or the performance of this can only be done by the patient's attending physician, and that it cannot be delegated to PAs. So we wanted to let PAs have them become aware of it in case they have patients, then they can realize they have to delegate that to their supervising physician. Any questions on this new law?
How does that get disseminated?
We have put it on our website. We have a information bulletin. We've also put on the news section what's new, and we have a link to that document as well. And we've included the actual law so that individuals can look at that as well.
Does the staff have any way of pushing information out to PAs? Is there like a listserv or anything?
We could do a blast.
Well, and I don't mean specifically with it doesn't necessarily need to be on this topic, but when there are new laws or regulations or other things that PAs need to learn about, do you typically just put it on the website, or do you do?
We put it on the website, and we can do the blast as well, so we can.
And I'm just curious. So about the blast, when do you do that? How often do you do that?
We haven't been doing it recently, but we have started doing it. And one thing we're also looking at is getting more involved in social media. That was part of our Sunset Report, and so we'll be working with the department to set up a Twitter account as well as a Facebook account as well. So we'll be doing that. Thank you.
I think Catherine brings up an excellent idea, but I think we really, with this situation, need to send out the blast, so that'd be great.
And this, the blast is only as good as the people that are signing up for it as
Right.
well.
Right.
And we don't have, we're doing fairly well, but we could have more subscribers
Correct.
possible.
I wonder if CAPA has any comment on this. I know often there's updates in their newsletter about new laws and things like that.
I was not aware that you did the blast. Are these people that subscribe to a particular, it's not everyone you have an email
No,
for?
you
It's
have
only-
to sign up for it. So,
Okay.
so we're trying to get the word out to licensees and applicants to sign up for it so they can receive updated information.
Yeah, unless you're a CAPA member, you don't really know when new regs have been promulgated. If you haven't signed up for that and you're not a CAPA member, for years you could go and not know. So it would be great to find a way to get to more of them. You used to do a newsletter, but that was 100 years ago, and the costs of doing that are too great. So yeah, I think we try to keep everyone abreast of what's happening. So maybe we need to put in our magazine how to sign up for that.
That
So
would
if
be
you get
very
me that
helpful.
information, we could do that.
Is there any way we can attach it to Breeze?
I'm getting no. I don't think I
Just the thought.
Please, God.
Could I ask a follow-up question on the cures thing? I know we're on a different agenda item, but I wonder if, because it is required by law for PAs to register for cures, do we check that when they renew their license and kind of advise PAs, hey, probably ought to sign up for this?
No, we don't. And I
Okay.
think part of it is that sign up and that tracking is with DOJ.
Right.
We wouldn't have the ability to go in. And there are, as I said, there are PAs that might have are registered and then for whatever reason, they're not using it anymore and they just let it go. So there's, you don't need that to practice in California. If you're transmitting scheduled drug orders, you have to have the cures, but if you're not, you don't need to have it.
Right.
So it's not a condition of licensure.
Was just thinking that this listserv blast and maybe social media would be another good way to let people know.
And we
kinda
did
how
blast that. We did
got it.
let them know that. Did you get one?
I did get one.
Okay, good. So it's
I'm
working.
on the blast.
And that concludes my report, if there's any more questions. Oh,
Okay.
public comment. Okay.
Further comment from the board? Okay, we will move on to licensing program. Anita Winslow.
Sorry. Our Breeze reports are back, so that's nice. We didn't have them last meeting, but we do have them again. So from April 11th until of this year, till June 30th, 2016, we issued 258 licenses, and we renewed 221 licenses during that time. And as of this date, we have 10,731 current licenses. Those current licenses do include current inactive, current family support, things of that nature. They're still active licenses, not the inactive, I'm sorry, but probationary licenses, which are current, and family support, which are current and can practice. Those are included in that 10,731. I also wanted to let you know that we do have a new vendor making our pocket licenses. They started July 1 of this year. It's CI Solutions out of Alameda. So hopefully things will get a little better with everybody getting their pocket licenses. And that concludes my report. Does any questions?
I have a question. On the Breeze report that includes the licenses and various statuses, it doesn't look like it reflects what's going on with, that I see in the other report for discipline.
I deliberately left those off.
Okay,
I can include them in the next report. It throws the total number off. I thought you guys wanted to know just those total current.
okay.
But we could always look at the first column, which would be the current, and then the last column would be all licenses in existence, whether they're canceled. If you have somebody that has died or whatnot,
I
that
was
would
just-
be in that total number, but I
Okay.
can run it that way next time if you prefer.
I was mostly just curious because I know we've had some problems with Breeze reports, and I was just wondering if this was
No,
still a
those were
problem or-
deliberately left off.
Okay, okay, thank you.
Okay. Next item will be Division Program Activity Report.
Okay, for diversion, we have, as of July 1st, a total of 14 participants. That consists of 5 voluntary referrals and 9 board referrals. And we've had a total of 139 participants since the program first came into being in 1990. Any questions on the diversion report?
I guess I have a question, and I know the total number of 139 is from the beginning of time. But you look at successful completion, and we only had 46 people successfully complete it. I don't know, it doesn't sound like we're doing a very good job of getting these people through
Well,
diversion.
I think we have to look at the public safety aspect of it as well, that we've had 46 that have successfully completed, but you also have to take into consideration there are a number of individuals that were not eligible, that we would run through the program and determine that they were not candidates. But I think that there again, you have to look at there were individuals that were not successful, and we had to take action to discipline their license because of that. So I think it's, you have to look at it from the consumer protection aspect as well.
Okay. Any public comment? Board member comment? All right, we will move on to Enforcement Activity Report. Lynn Forsythe.
Good morning.
Good morning.
For the period of April 1st through June 30th, we had 3 probationary licenses. We had 1 revocation and 4 surrendered their licenses to us, and 1 probationary license that we issued. We filed 6 accusations this particular couple of months, and we have 1 interim suspension order that we obtained. We've initiated 4 additional cases at the Attorney General's office, and currently we have 46 cases pending. Cite and fines, we have 5 pending from our last fiscal year. We issued 12 this year and closed 1. So total fines issued are $3,200. We have 49 active probationers, 5 are currently tolling, and we received 128 complaints, and we currently have 140 assigned for investigation. Any questions?
Are we ever going to be able to get from Breeze aging of cases?
The reports they're being worked on, yes. Yeah, we have a new version coming out hopefully within the next 4 weeks.
Okay.
I think good progress is being made
It is.
to ensure that we have accurate data. It's better to report accurate data than just have a report that's non-reflective of what we're actually doing. We have to defend the report.
Okay.
Lynn, I have a
Public-
quick question, Bob, if that's okay.
Yes.
Can you explain what happens when a complaint is assigned for investigation? What does that mean? There's a lot of complaints there that have been assigned.
It means that someone from the public has filed a complaint against a physician assistant. We have obtained all the necessary documents. It's been reviewed by 2 or 3 people, and then the decision has been made to send it out to the field for further investigation, whether it's undercover, if it's interviewing the complainant, that's it, 2 investigations.
Okay. And that number, 140, that just seems like a large number to me. Is that,
A lot of cases going out. We're
Okay.
getting a lot more than we've ever had lately.
Shelley Jones.
okay.
Jones.
And do you have any idea why we're getting so many more complaints? Is there any trends that maybe we could identify?
Yeah, sure. I think we're starting to run into a lot of overprescribing complaints. We're also getting complaints from consumers that are not happy that the PAs have cut them off from prescriptions. The overprescribing complaints are very complex because we have to receive cures reports. We have to pay consultants to go through the reports and give us recommendations as to if the treatment was appropriate. So I see that's kind of the new trend, is we're getting a lot of those reports. I think this is where, I know we've had discussions about the value of the cures report. This is where I think, as a practitioner, it's very important to actually run those reports because, as I said, we're starting to get a lot of consumers that view their controlled substances as almost sort of a right, and now they're being cut off or they're not receiving them, and they're upset that this isn't continuing on, and either the PAs recognize that there's not a need for this type of medication anymore. And so the cures report, in a sense, will protect that practitioner, because if these people are now filing complaints, they're not happy with not receiving their drugs.
Okay.
But those cases have become very complex because they involve oftentimes another healthcare practitioner, such as a physician. But the immensity of having to pay consultants to look at the data and render some sort of a decision is very time-consuming and costly. But I see those as kind of the new.
Thank you. The assigned for investigation, does that mean that the consultants have looked at it and have decided that there is some merit and then it goes for further investigation? Or does that mean that it's just been sent to the consultants for them to decide whether or not there's merit?
Assigned investigation is generally, as Lynn had said, after there's a review. There are cases, say, conviction of a crime that don't necessarily need to go to a consultant because it's sort of evident if you have 3 DUIs.
Yeah,
You
that's
need to go.
obvious.
But there again, usually a consultant will render some sort of an opinion as to if there's a potential violation, and then that would be assigned to an investigator. There are cases as well where Attorney General is also looking at the case and will recommend that the case go to investigation, because ultimately it will move up to their level.
Okay, thank you. Last question. What time frame is this in, the 128 received?
April 1st to June 30th.
So in the last 3 months, there were 128 complaints? Wow. Okay.
I think
Thanks.
the internet, the availability of how to complain is easier, as well as there's notices that must be placed in a PA's office of where they can call or contact to file complaints. It doesn't mean every complaint is going to merit some sort of investigation, but I think it's now becoming easier for consumers to, and they're becoming more aware of situations too.
So maybe not necessarily that more mistakes are being made or problems, just more that there's an awareness and ease of filing a complaint?
And we receive complaints that aren't necessarily complaints, and they might not really be related. You know, the PA wasn't nice to them, or I can't get my records, things like that. So we do actively look at them and we do respond to them, but just because a complaint is received doesn't mean it's going to go any further.
And about how many of the complaints that are received have some merit? What percentage-wise, just approximately?
I would say maybe half of them, but there again, it doesn't mean that it could go to the consultant. The consultant could look at it and say, no, there's nothing here.
Okay.
And so we rely on their expertise to sort of determine that.
Okay, great. Thank you.
I have a quick question regarding the number of complaints. Total received was 128 versus assigned for investigation 140. The difference of the 12 is,
They were just kind of hanging over from the prior quarter. They just hadn't been completely worked yet.
okay. And then my last question is, does the medical board, and maybe Michael can speak to this, does the medical board find the same increase in investigations versus the cures? Is the medical board having the same issue that we're having?
I'm not aware of it. It may very well be, but I haven't any information at all yet.
Okay. Thank you.
I have one question. The Office of Attorney General cases, is this a trend that's increasing, or is it pretty typical for this amount?
I think it's increasing as we've noted our budget, we're overspending on that line item. And I think there again, the cases are becoming more complex. PAs are now interacting more with legal counsel, and there are more complaints.
And there's some reason to adjust budget to address this particular issue?
You have the legal authority for the budget augmentation if it appears that your budget is being overspent. There are there are laws that will allow, as we've done in the last couple of years, to augment the budget to accommodate those increases.
Okay, thank you.
I have one question. Are we doing vertical enforcement or not?
We are not legally required to do vertical enforcement, but there are cases that we will allow that to happen generally if it's, say, a sexual misconduct case or a case where we recognize it'll go to the Attorney General, but we are not legally mandated to participate in that program.
Okay, because that seems like a very expensive, giant step
It is.
Could,
to bring the Attorney General in early on.
for the benefit of some of our new members, could you explain what vertical enforcement is?
Vertical enforcement is where early on in the investigative process, the Attorney General works closely with the investigator to develop the case for ultimately for the Attorney General to take it over and prosecute the case. The medical board, I believe, is legally mandated to participate in the program, but we are more or less voluntarily able to participate in it. We don't do a lot of them, but as I said, generally, if it's going to be, say, a sexual misconduct case, it might be a time saver in actually participating in it because we're ultimately going to get there anyway. So it's better to make sure we get what we need early on, so that when we get to that point, we're pretty well have the case under control and everything the attorney needs.
The downside of it is, as soon as we involve the Attorney General, the dime starts falling down. And it's usually more than a dime.
Couple of them.
Okay, next item on the agenda is...
Can I make one more comment before you move on? I'm just wondering if there's any concern to monitor and to watch this particular issue, just for sake of any kind of intervention or preventive kind of remedies that could be put in place to keep these numbers from going up or down or whatever.
Well, are you talking about the number of complaints we receive, or?
Or cases,
Well,
complaints?
I think you can't, I think consumers are going to, there's really no way of knowing how many people will file complaints every year. As you're aware, we also are now participating in the 800 series reports or requirements where hospitals are now reporting individuals, insurance companies. I think you always should monitor your enforcement to look at trends, and hopefully you can look at this as an educational aspect for your licensees.
That's what I was
areas that are
concerned.
And as I said earlier, I think this is a good lesson for, looking at the cures report to make sure that you do have a patient that is not drug seeking, that they are, you say no. And I think what we're seeing now, as I said earlier, a lot of complainants are being cut off because perhaps the practitioner is reviewing the report and seeing these things, or that their contract requires they get drug tested and they're testing positive for amounts or drugs that are not part of the contract, and they're kicking them out of the practice. And I think we see that trend. But I think that the lesson is always, if you see this, if you're doing it or you're aware of it, you should be taking steps to ensure that you're not hopefully going to get into the same spot.
Okay.
Yeah, Charles, I gave a talk recently at Torrance Hospital, and there's a lot of fear out there now with the new guidelines amongst practitioners, and somewhat rightly so. But I think there's also a lot of misinformation about the guidelines and how we're using them. But I think this is not the first time. If you look at the history of this issue, in the past, before pain became the fifth vital sign, there was a lot of pushback from consumers, like we're seeing now. Then pain became the fifth vital sign. With help of big pharma, this became a crisis and an epidemic, and now we're having the pendulum swing back the other way. So hopefully, with more education, more training of all involved, we're going to start seeing the pendulum swings moderate. I'm hoping so, but yeah, we probably have not seen the peak yet of the complaints and the concerns from the consumer side.
Okay.
And I think we encourage our licensees to take advantage of the pain management guidelines that were developed by the medical board. I find I've received calls from PAs that really don't know what to do with patients that are in these situations. And I'm assuming that means the physician doesn't either. And so I think those guidelines are very helpful in trying to determine how you manage a pain management type of patient and make sure that they're getting what they need versus are they not getting what they need, diverting.
And Glenn, with reminder, I'll certainly bring this up at the next medical board meeting and see if they are seeing a similar trend. And because it's alarming, what can we do? The patients need to have pain control, and we need to find out the right balance for this. So please remind me, and I will do so. In fact, I'll try to make it over today and talk with Kim Kirchmeier and see if we want to put that on our agenda coming up.
I think the other thing that will really help is when we can get our old reports back like we used to have, where we have a much better handle on where the cases are in the AG's office. I mean, in the old days, we'd have cases that were sitting there for 3 years, and it would be why. And all that time, the clock is ticking and the money is flowing, and we're not getting any results. And since we had to switch over to Breeze, we've been unable to get those reports, which I was very proud that we had for years, and they were very accurate. Gave us a very good picture as to what was going on with our enforcement. Okay, public comment. Next item will be Department of Consumer Affairs, update on departmental activities. Christine Lally sent me a text. She is unable to attend. She's doing about 10 other things today. So Shelley Jones is taking her place.
Good morning,
Good
President
morning.
Sachs, members. Thank you for the opportunity to address you today and share with you some information on behalf of the department. I am Shelley Jones, and I am a manager in the Board and Bureau Relations Unit in the Executive Office. I have several pieces of information for you today. First, we've had a couple of changes in our executive team staff. As you may have heard, Melinda McLean, the Deputy Director of Legislation, took a new position at the Governor's Office. So she's no longer with us, and there's been no replacement at this point yet. We certainly wish her the best of luck in her future endeavors. And on June 28th, Jeff Mason was appointed by Governor Brown as our new Chief Deputy Director for DCA. Jeff has been with the department since 2013, serving as Chief for the Bureau of Security Investigative Services, and most recently as Chief Deputy Commissioner for the Bureau of Real Estate. We're excited to welcome Jeff as a new member to our team. DCA sent out a training needs survey to all EOs and board members to assess their training needs as the department works towards developing training specifically for new executive officers and the next generation of executive officers, as well as training provided to board members. The survey for EOs closed on June 30th, and the board member survey will close on July 15th, 2016. We very much appreciate all the feedback that we've received from the EOs and the board members. And once all the information has been gathered and all the responses reviewed, we will look at the data and begin refining the current and developing new training. DCA's Solid Team held its first brown bag gathering on May 11th at the Sierra Health Foundation. These gatherings serve to generate networking opportunities as well as training for EOs and assistant EOs. The next gathering is scheduled for Wednesday, July 20th. And another quick reminder, the board member orientation training, the next one is scheduled for Thursday, September 22nd here in September. You can contact the Solid Team if you're interested in attending. In addition to developing EO-specific training, the department is also finalizing a process to assist boards with onboarding new executive officers, the first of which is taking place today. We believe this will greatly assist boards bringing on new leaders. Part of the process will include making all DCA division heads available to the new EO for a briefing on the services provided by that division and the work currently in process between the division and the board. For example, the Division of Legislative and Regulatory Review would meet with the new EO to review recently passed and pending legislation impacting the board, as well as to discuss the legislative and regulatory process. DCA will also provide a transition binder that the new EO that includes information on the department and the board, such as contact lists, strategic plans, organizational charts, fund conditions, and those items that will help bring the new EO up to speed. As part of DCA's strategic plan, Solid is implementing a mentoring pilot program. The pilot is voluntary, but if the board wishes to participate, they can join by contacting Solid's manager, Damon Nelson. The pilot affords line staff a great deal of flexibility to learn from various participating managers. In addition to some DCA units, the boards and bureaus currently participating in this program include the Board of Optometry, the Board of Vocational Nursing and Psychiatric Technicians, the Medical Board, the Professional Fiduciaries Bureau, Bureau of Automotive Repair, Acupuncture Board, and the Bureau of Electronic and Appliance Repair, Home Furnishings, and Thermal Insulation. On the subject of the strategic plan, DCA will be launching the development of a new strategic plan this year, and that should become available sometime next year. In regards to Breeze, the Physician Assistant Board is seeing a good number of applicants using the online portal for the purposes of renewal. In June, approximately 45% of all renewals approved were received via the online portal. Those who choose to submit renewals online see a dramatically quicker turnaround for their application approval. Of those renewals submitted online in June, all were processed in 1 day or less. Those who mail in their application typically see their renewal processed in 1 to 2 weeks, provided the application is complete. As Glenn had mentioned, one of the 2 outstanding requests for system changes is the implementation of the address change application, which is currently scheduled to be resolved at the end of the month. And then also the department has implemented a new reporting tool named, and they call it QBERT, which stands for Quality Business Intelligence Reporting Tool. This tool allows boards and bureaus direct access to build, edit, and run reports to suit their business needs. DCA resources are available to assist boards and bureaus if some training is needed to understand and use the tool. This tool will be supplemental to the reports and data extracts already available to the boards and bureaus through Breeze. And with regard to your legislation and regulatory activities, I have a report from the legislative unit. They indicate they have received and begun analyzing your regulatory proposal to amend CCR 1399.546 relative to the reporting of physician assistant supervision. The regulatory proposal is scheduled for a hearing and discussion later this morning. Additionally, your Sunset Bill AB 2193 has moved through the legislature without any dissenting votes and is scheduled for hearing in Senate Appropriations on August 1st. At this point, the department does not anticipate any issues with that could prevent its passage before the legislature adjourns at the end of August. And that's all I have for you today. Any questions?
Thank you. Member questions?
I have kind of a peripheral question. A couple of board members, myself included, were unable to attend our scheduled board member training because of financial issues with the board.
Okay.
And I'm concerned about getting that done within the timetable that we have. It's a year, I believe, from your
It's a year,
appointment.
yes.
And is there any leeway if that can't be done?
Let me check on that and we'll get back to you.
Okay, great,
I'll
thank
check
you.
on
We
that for
work
you.
with Glenn or see when we can get this done, just to stay within statute.
Okay, sounds good. Thank you.
Okay, thank you very much. Let's talk to council for a minute.
Is it 10?
Okay,
Do you have your reg speech?
yeah.
Okay.
I do that at 10.
10, okay.
All right, it's already 10 o'clock.
Is it 10 o'clock? Okay.
Can we take a 5-minute break?
No.
Gotta do it.
Okay. We will go now, we will skip a little bit and go to item number 10A, which is a regulatory hearing on proposed language for reporting of physician assistant supervision, section 1399, 546, of Division 13.8 of Title 16 of the California Code of Regulations. So I will call the hearing to order for this regulatory hearing. My name is Robert Sachs. I am the president of the Physician Assistant Board, and I will be presiding over this hearing. This is the time and place set for the Physician Assistant Board to conduct a public hearing on the proposed regulatory changes to Title 16, Division 13.8 of the California Code of Regulations as described in the notice published in the California Regulatory Notice. As you may be aware, Business and Profession Code Section 3502 authorizes the medical services performable by a physician assistant, the supervision requirements of physician assistants, and supervision record-keeping requirements. Existing law, Title 16, California Code of Regulations, Section 1399-546, requires the physician assistant to enter the name of their supervising physician in the patient's medical record every time they provide care for that patient. Section 1399-546 was adopted prior to the now wide use of electronic medical records and the automated or computerized entry of required medical information in medical records of patients. SB 337, Chapter 536 Statutes of 2015, Pavely, amended Business and Professions Code, Section 3502. Among the amendments was the requirement that the medical record for each episode of care for a patient identified the physician and surgeon who is responsible for the supervising of the physician assistant. Business and Professions Code 3502F also was amended to state compliance by the physician assistant and supervising physician and surgeon with this section shall be deemed compliance with Section 1399-546 of Title 16 of the California Code of Regulations. Upon review of its interpretation of Section 1399-546 and the recent amendments to SB 337, the board determined that Section 1399-546 is not consistent with the intent of the Business and Professions Code, Section 3502, as amended by SB 337. Specifically, the board determined that SB 337 was intended to alleviate the need for the physician assistant to manually enter the supervising physician's name in the patient's EMR for each episode of care. However, the current regulation still may be interpreted to require that entry. This proposal would strike the current requirement that the physician assistant manually enter the name of his or her supervising physician in the patient's medical record for each episode of care, and instead require that the physician assistant only record the supervising physician in the patient's medical record for each episode of care. This would permit use of EMRs or other methods of recordation to meet this record-keeping requirement. The proposal would also add a paragraph to Section 1399-546 that explicitly permits the use of EMRs to meet this requirement, provided that the electronic medical record software used by the physician assistant is designed and actually does enter the name of the supervising physician for each episode of care into the patient's medical record. Such automatic entry would be deemed sufficient compliance with this record-keeping requirement. For the record, today's date is July 11th, 2016, and this hearing is beginning at approximately 10 o'clock. Will the secretary please call the roll to establish for the record that a quorum is present?
Charles Alexander,
Present.
Michael Bishop,
I'm not a voting member, I don't believe I should be on.
sorry, Jennifer Carlquist,
Present.
Sonia Early,
Present.
Javier Escobar Acosta,
Present.
Jed Grant,
Present.
Catherine Hazelton,
Present.
Xavier Martinez,
Present.
Robert Sachs,
Present.
Mary Valencia.
Present.
Okay, we have a quorum. At this time, the hearing will be open to take oral testimony and documentary evidence by any person interested in these regulations for the record, which is now being made by tape recorder. All oral testimony and documentary evidence will be considered by the Physician Assistant Board pursuant to the requirements of the Administrative Procedures Act before the board formally adopts the proposed amendment to these regulations or recommends changes which may evolve as a result of this hearing. If any interested person desires to provide oral testimony, it will be appreciated if he or she will stand and come forward, give his or her name and address, and if he or she represents an organization, the name of such organization, so that we will have a record of all those who appear. It is the desire of the board that the record of the hearing may be clear and intelligible, and that the hearing itself may be orderly, thus providing all parties with fair and ample opportunity to be heard. Are there any questions concerning the nature of the proceedings or the procedure to be followed here before we begin? Public comment on procedure? Okay. If not, we will proceed in chronological order to consider the board's proposed regulations. The first person to testify is?
Good morning. Teresa Anderson on behalf of California Academy of PAs. We'd just like to thank you all for all the work and time that went into this. We know it was quite a robust conversation and stakeholder process as well. And we're in support of the changes and appreciate all that you've done to make this happen. Thank you.
Thank you. Any additional individuals that wish to testify? Since no one else wishes to speak, the hearing is now closed. Now, can we take a break? Sure. I think we will take a 10-minute break at this time. Oh, okay. Are we ready, Lou? Okay, so item number 42 on the agenda is recognition of our current executive officer, Glenn Mitchell. Glenn is going to retire September 1st, and we do not have another board meeting between now and then. I have known Glenn, I believe, the entire time you have been with the PA board, which is 31 years. He's done every task and held every position within the PA board when we were the PAEC, and then when we became the PAC, and now we're the PAB. And he's done all of his tasks with outstanding work ethic. I have given him one task which he has not completed, which I asked for about 3 years ago, which was to write a short history of the PA board in general from its inception, because he's the only one that's been around the whole time. So he still has that task between now and September 1st. So Glenn, I want to thank you for all your efforts. It's been a pleasure to have you as our executive officer. And if you would come up to the front, we have something. So I will read the plaque. It's to Glenn Mitchell in appreciation for your 31 years of dedicated service to the Physician Assistant Board. You not only have served the consumers of California, you have had a major impact on the physician assistant profession. You have always achieved the highest standards as our executive officer. You will be missed. Enjoy your retirement. And this is presented by the Physician Assistant Board on July 11th, 2016. Okay.
Thank you.
You can say some words
All
when you
right.
get to the back, and so can all the other board members.
Well, thank you for the honor, really appreciate it. It's hard to believe it's been over 30 years. It's lots of changes and the way the profession has grown and matured and how consumer protection has changed and evolved as well. I've enjoyed working with everybody. It's been fun learning from legal counsels through the years and board members and wonderful staff. And I'll miss all of you, and I'll be around. And thank you very much. I appreciate it.
Thank you. Board members want to make any comments?
It's been great having you as our EO, and we are so excited for you and your next phase of life. But we're definitely going to miss you. So, but congratulations.
Thanks.
Public comment?
I'm jealous. I'm so jealous. Good for you. You and I have been around about the same amount of time, and we've spent many hours talking about the trials and tribulations of PAs and the joy of working with and for them. So we wish you the best.
And I think I remember, the first time I met you was, I think, your Kappa convention in Sacramento at the Hilton.
Oh, wow.
And probably there were like 40
88.
people there.
40.
It was very small.
We've grown a bit.
So you've grown a bit, so I've
Best
enjoyed.
of luck, and I've
Thank
enjoyed
you.
working with you.
Thank you.
Thank you.
It has been such a pleasure to work with you, Glenn, and I wish you the best and at least a postcard from Hawaii.
Okay. Thank you.
Okay.
Just
Again,
really-
thank you so much.
Real quick. So just from the legal office's perspective, we've always felt like you were the go-to executive officer. You always were very responsive, willing to listen. I mean, you have your own discretion, of course, we know that, but you were always really willing to listen. You always took all the information you needed before you make a decision, and that is very much appreciated from our perspective. But just always the willingness to roll up the sleeves and dig into the issues and work whatever issue is to get something done was, I always thought was fantastic, and we really are going to miss you.
Thank you. Thank you.
All right, now that we've anointed you. We're going to take things out of, okay, so we're going to go to item 10A, which is regulatory, I'm sorry, I'm going to 10B. Discussion of possible action to amend Title 16 California Code of Regulations, Section 1399, 546, reporting of physician assistant supervision, which is what all that 4 pages of information I read to you a few minutes ago. So, Christy?
So you heard from the introduction that Board President made at the beginning of the hearing, the requirement that is being changed is the reporting, and it's just to make it clearer and more consistent with the legislation that was enacted earlier this year, that you can record in the medical record through the use of an electronic medical record software program instead of having to manually enter it in. That's the current regulation. So it's being amended so that it's clear that it's also acceptable to have an electronic medical record software system enter that information automatically. So it's sort of kind of to update things and make sure that we're more consistent with modern technological times. So One comment that was received from the California Academy of PAs was a mistake. We overlooked the language, obviously, should be changed consistent with the comment in subdivision B of the proposed regulatory change. The word assistant should be struck, so it says enter the name of the supervising physician for each episode of care. That was something we struck at the board meeting but didn't carry over into the formal filing, and so I would recommend that the board accept that comment and make that change to the proposed text. So if you go to the next page after agenda item 10, you'll see on the second page it says actions. So our recommendation, the first motion should be to accept Kappa's comment to strike the word assistant from the third line of subdivision B.
I'll make the motion.
Thank you.
I'll second.
Discussion? Public comment? Okay, our call to vote. Dr. Alexander?
There was a comment, I think.
Oh, there is a comment?
Yeah.
Okay.
Sorry, Bob. No, I'm sorry.
Gotta move.
I did mean to mention that in the regulatory hearing, but I assumed that reading in the text that it was already stricken. So we do appreciate your working with us in the acceptance of that, and we do know that it was the original intent of the change. So I appreciate that very much.
Thank you. Okay, further comments? All right, I will call the roll. Dr. Alexander?
Aye.
Jennifer Carlquist?
Aye.
Sonia Early?
Aye.
Javier Escobar Acosta?
Aye.
Jed Grant?
Aye.
Catherine Hazelton?
Aye.
Xavier Martinez?
Aye.
Robert Sachs, aye. Mary Valencia?
Aye.
Okay, so the motion to accept the removal of assistant is approved.
Okay, and the second part of the rulemaking process is to complete the process and adopt the text. And so what you have to do is, for the new members, is because the staff prepare the packages, you have to, but you're the rulemaking body, you have to delegate your authority to your staff to finish the process. And if you're okay with the way the text is written, which apparently you are, then we would recommend the second motion, which is to direct staff to take all steps necessary to complete the rulemaking process, including preparing modified text for an additional 15-day comment period, which includes the amendment to remove the word assistant as discussed at this meeting. If after the 15-day public comment period, no adverse comments are received, authorize the executive officer to make any non-substantive changes to the proposed regulations before completing the rulemaking process and adopt Section 1399.546 of the proposed regulations with that modified text.
I'll make the motion.
Thank you.
I'll second.
Discussion.
I have a question. So it's clear that with section B here, that if an EMR is used, then it can record in the medical record for that episode of care. That's the supervising physician. But I'm wondering if there is not electronic medical record software being used, given how we've written this in A, would the PA still be required to write the physician's name every time the physician enters, or the PA enters his or her own name, or would that still just be once for the episode of care?
So the reason that it was changed was to allow for all methods of recordation, not just manual or electronic. So whatever method is used, it can be electronic, it can be other, whatever electronic means that are used. You just have to make sure that it's recorded each time for each episode of care. So I think that the amendment was truly intended to open up all possibilities for recording that information for each episode of care. So that's not being modified. What's being modified is the prior, or the existing rule, I should say, requires manual entry each time.
Yeah.
And so by changing it to recorded in the medical record, it includes manual or electronic or other EMR or other types of recordation. As long as it's being recorded each time for each episode of care, it would be compliant.
I totally get that. I think that there was a separate conversation, and I may have misunderstood it, but that there was also an effort here to suggest that every time a PA entered his or her own name, they didn't also need to enter the name of the physician, but that if that there was a desire here to say that only once for the episode of care they had to enter the name of their supervising physician. So I was wondering if we were attempting to reduce the number of times, if there were manual recording, reduce the number of times that a PA had to provide the supervising physician's name, so that it only was for once for each episode of care, but not for each time that they were submitting their other information or charting something.
That's correct.
Okay, so if that is correct, I don't think that this is I think there might be a mistake in the way this is written, because it says each time a PA provides care for a patient and enters his or her name and other information, the physician assistant shall also record in the medical record for that episode of care. And that's confusing because it's saying each time they have to do it, it's not saying that for that episode of care they need to, or that the supervising physician's name only needs to be entered once for the episode of care.
So I think the addition of the sentence for that episode of care, which we added, was specifically to address this. So before the sentence is added, if I see you and I walk away and I come back 10 minutes later, I have to re-enter all of that information, which is still one episode of care. So I don't think that there's no substantive change to the intent of what the regulation is doing, which is identifying a supervising physician for the episode of care. What you're doing here is relieving duplicitous documentation requirements. So it doesn't change anything about how PAs are practicing, just relieves them of a requirement of documenting the same information over and over and over. So the addition of that statement, episode of care, actually allows them to do that. It doesn't relieve them of the requirement to document who the supervising physician is. It just relieves them of the requirement to document it over and over for the same episode.
I totally get what you're trying to do. I just don't think this language does this, because this language still says each time a PA enters this information, the physician assistant shall record in the medical record for that episode of care. And that it's just really clunky language, because it still says that, each time, it's odd. It's saying each time the PA provides that, it should be saying they need to do something, but instead it's saying something different. It should be a separate sentence that says, if the PA, or the PA only needs to, write this once for each episode of care. Right now, the way the sentence is structured, it doesn't specifically. I don't think it alleviates the burden for the PA not to have to provide that duplicative information.
I disagree. Seems clear to me, but something for the board to discuss.
I think that for that episode of care was intended to qualify the entire sentence, and that's how I read it. I suppose there's always a disagreement about whether it could have been clearer, but I think that, to me, it seems clear that it's for each episode of care. So I mean, I'm totally open to changing it if the board members feel like it should be further clarified, or if there's another way of writing it, and it's totally your call, because this is your text.
If our lawyer on her way out thinks that this is clear, then I don't want to hold up this process. To me, it reads very strangely and doesn't seem clear, but if you're comfortable with it, I think that's fine.
Further discussion?
I think at the episode of care may be the issue that you're speaking of, but help me if I'm incorrect, but every time that, say for instance, if your child came to the emergency room, that would be an episode of care. And anytime I would sign my signature, the supervising physician's information would be there as well. if your son or came back later on tonight, that would be a new episode of care and my signature and the supervising physician. So I think it was written so to take out the duplicity, but every time there's an episode, my signature and the supervising physician signature will be there. So I think there's probably, we're saying the same thing, but I can see how it wouldn't be clear if the episode of care got, wasn't clear. I hope that helps.
Thanks.
Further discussion? Public comment? Okay, I will call the roll.
Oh, was there a motion?
Yes, I thought
Okay.
Jed made it and
I seconded.
Mary seconded. Okay, so Charles Alexander,
Aye.
Jennifer Carlquist,
Aye.
Sonia Early,
Aye.
Javier Escobar Acosta,
Aye.
Jed Grant,
Aye.
Catherine Hazelton,
Aye.
Xavier Martinez,
Aye.
Robert Sachs, aye. Mary Valencia.
Aye.
Okay, the motion carries, so we will direct staff to take all necessary steps.
Thank you.
Thank you. So now, where do you want me to go?
Go to closed session. Closed session and we'll after one.
Okay, so we are going to skip around some more, and we will go into closed session. Item number 1 will be pursuant to section 11126C3 of the Government Code. The board will move into closed session to deliberate disciplinary matters. As soon as we have finished that, pursuant to Government Code 11126A, the board will meet in closed session to consider the possible selection, appointment, or employment of an executive officer, including appointment or employment of an interim executive officer or acting executive officer. So we will go into closed session at this time. Thank you.